Thank you so much for joining us to talk about medical marijuana, the budding industry that's impacting employers. My name is Mariah Collins, and I'm an HR consultant. Oops, there we go. My name is Mariah Collins. Sorry about that. I'm an HR consultant with Axcet HR Solutions, and I am so excited you're here. We've been working diligently on this presentation for you all and have been looking forward to providing you some new information related to big changes that are happening with medical marijuana, particularly in Missouri and Kansas. Please feel free to add any questions you have in the chat box, and we will be sure to address them at the end of the webinar today. If your question does not get answered, I'll be sure to reach out to you directly to get you the answers that you're looking for. We will also be sending out a copy of the slide deck and a recording of the presentation later this week, so keep an eye out in your inboxes for that over the next day or so. With that being said, let's get started. So to get us up and going today, I wanted to give you an overview of our objectives for our training. We're first going to review the current and pending laws surrounding the use of medical marijuana and the quickly changing public opinion. We'll develop some awareness of the impact that medical marijuana is having on our employment practices and the life cycle of the employee. We'll discuss tension between the trends in state law versus federal law. And we're going to provide best practices and takeaways for owners and managers to effectively address those changes. To get us up and, oops, sorry about that. With that, I'd like to begin by talking about the legalization of marijuana across the country. As you can see, we have a ton of green states here, with dark green meaning that state law legalizes the use of marijuana for both medical and recreational purposes. Light green meaning that the state law is legalizing the use of marijuana for medical purposes, and gray is meaning that state law does not permit either at this time. However, it's important to remember that at the federal level, marijuana remains completely illegal. The state laws really started in with a snowball effect back in 2012 when Colorado and Washington became the first states to legalize recreational marijuana. And we now have a record 36 states that have legalized marijuana either recreationally, medically, or both. There's quickly changing public opinion regarding the views of legalizing marijuana. According to an October 2020 Gallup poll, about 68% of Americans are supporting legalizing marijuana at this time, with consistent views across all US regions that it should be legalized. This is up from 12% in 1969, with a major spike in support doubling just over the last 20 years. The majority of most demographic subgroups are supporting legalization. So across the board, that's males, females, all age groups, non-college grads and college grads alike, and all household incomes all hold a majority view that marijuana should be legal across the United States. 83% of Democrats and 48% of Republicans are supporting legalizing marijuana as of 2020 as well, which is up from 32% support for Democrats and 22% for support in Republicans in 2000. Something new that happened, marijuana in the news, Amazon dropped their marijuana screening. Earlier just this month, they made an announcement that they would no longer test most applicants for marijuana use. Most is referring to any position that's not regulated by the Department of Transportation. So those safety sensitive positions like your delivery drivers will still be subject to marijuana testing. On top of their announcement to no longer test most applicants, Amazon came out publicly and stated that they actually support legalizing marijuana federally under the Marijuana Opportunity Reinvestment and Expungement Act, or the MORE Act. The MORE Act supports legalization of marijuana at the federal level and supports removing it from the Federal Controlled Substances Act. The passing of this act supports having records expunged for those with cannabis convictions and also supports creating a federal tax on marijuana with the intention that the revenue gained would go directly to community reinvestment programs. With a company as large and prominent as Amazon dropping marijuana from their screening panel and supporting the legalization and decriminalization of marijuana, many organizations are sure to follow suit. This will likely prompt mass support across many industries for marijuana legalization, and it will be so important to stay up to date in the coming months on the quickly changing news in relation to that legislation. Moving on to talk a little bit about marijuana in Missouri specifically. Marijuana use for medicinal purposes was signed into law by first legalizing CBD oil for seizures in Missouri. Decriminalization of the substance went effective in January of 2017, meaning that possession of 10 grams or less was punishable by fine only. In Kansas City specifically, possession of up to 35 grams is just an infraction with up to a $25 fine. And in Jackson County, the prosecutor will not file simple possession cases. Amendment 2 took effect on December 2018, which fully legalized marijuana, allowing qualifying patients to purchase and actually grow marijuana for qualifying medical reasons as defined by a physician. Since legalization in Missouri, here's what's happened with medical marijuana. Medical marijuana went into effect in December of 2018. In June of 2019, the state posted application forms and instructions were posted based on those finalized rules. Between August of 2019 and April of 2020, the state actually began reviewing facility license applications for the distribution of medical marijuana. Patient applications were received and surpassed 21,000, which was over 2,000 more than was anticipated. The final applications received as of March 2020 were nearly 45,000, over double initial projections. The testing of those sales facilities we talked about began and licenses were awarded. Since April of 2021, there have been over 93,000 medical marijuana cards issued statewide. There are over 80 dispensaries in the state, which has quadrupled since 2020. The industry has been massively successful, with projections of over 200 million in revenue expected by the end of just this year. Recreational marijuana is also on state legislation's mind, with talk of ballot proposals already for 2022. Moving along to talk about marijuana in Kansas. Kansas is trailing along behind Missouri, but not by much. Although there's still no legalization or decriminalization in Kansas, the legislation is on its way. In May of 2021, Kansas took huge steps toward legalizing medical marijuana, but they did put in place some serious restrictions. They put in place that counties could opt out of medical marijuana if the bill was passed. Patients would absolutely have to obtain a prescription from a physician that they've been under care for at least 6 months. There would be a list of about 20 set medical conditions for which medical marijuana could be prescribed. The bill would have provisions ensuring that the forms of medical marijuana could not be smoked or vaped. Physicians would have to be certified, of course, by the state to prescribe that medical marijuana. Employers could still ban employees from using marijuana, even if it was obtained legally for medical reasons. And if the bill was passed, there'd be an amendment that required conditions on the list to be reviewed at least every 3 years, with the potential to be removed if evidence about those benefits of medical marijuana were to change. Additionally, there are major concerns with Kansas officials when it comes to legalizing medical marijuana, as many feel it leaves an open door for recreational marijuana to follow suit. However, Governor Laura Kelly does support the legalization of medical marijuana in Kansas. The Kansas House actually voted in May of 2021 to legalize medical marijuana. However, after it was presented in the House, the bill died in the Senate. It's likely not to be brought forth again until 2022, but it is on the horizon for Kansas as well. So after giving you some background on medical marijuana, I'm sure your mind is just swimming with questions as an employer or a manager, such as how will this law impact pre-employment and reasonable suspicion drug screening? Do I need to stop conducting my random drug testing? Should I start testing now? Can I remove marijuana testing altogether from my drug screen panel? Is that recommended? What's my liability? What if my employee fails in post-accident drug test but has a medical marijuana card? Or I'm a Kansas employer with employees that live in Missouri. How does this apply to me? I'm sure you have a ton of other questions as well. And fortunately, we have Brent Coverdale here today on our webinar to help. So let's ask Brent. Brent Coverdale is an employment litigation and counseling practice group chair of Scharnhorst Ask Kennard Griffin PC. Brent has vast experience assisting clients with litigation and counseling matters throughout the country, and we at Axcet work very closely with him on a day-to-day basis. In addition to general commercial litigation, Brent's practice focuses on employment law, including administrative agency proceedings, civil litigation, and trials. And with that, I will turn it over to Brent.
Good morning, everybody. Thank you, Mariah. Basically, we are going to walk through kind of the litany of issues here. There are a lot of questions. Fundamentally, I think that there's hopefully straightforward answers, or at least that's what we're going to strive for here. So let me start with kind of some issues regarding medical marijuana in particular, as opposed to recreational marijuana, as opposed to other forms of substances that we're going to talk about a little some today. One of the issues that you run into, that employers run into, is by calling it medical. When we talk about marijuana, when we legalize it for medical purposes, on the one hand, it helps with the public reaction, but by calling it medical, then that adds complexity for employers. You then have to deal with it in terms of accommodation type standpoint, or at least think about it in those terms. And we'll talk about that as we go. Another issue with medical marijuana versus alcohol, alcohol is one of those substances, it's perfectly legal. It has chemical reactions that arguably help as well, but it's not medically accepted as a treatment. So with alcohol, there's alcoholism issues with the ADA, for example, but you don't go get a prescription card for alcohol that then invokes the sort of things that you have to think about as an employer when you're dealing with medical marijuana. So again, we'll talk about those. And another thing that is a difference with alcohol as opposed to marijuana we'll talk about is it's easier to test for both current impairment of alcohol and the level of impairment of alcohol, which makes a big difference as you're kind of working through some of these issues. Let me just sort of preface everything about marijuana with this one concept. It used to be a lot simpler when it was as simple as the individual takes a drug test, fails the drug test for marijuana, and then you move from there. Now, most of the time, there's other things that you have to consider. The good news is it's not particularly complicated what you have to consider, but the point is it's not as simple as it was before, where failed drug test, black and white, that's the end of the analysis. It still is in some situations, like Department of Transportation regulated. We'll talk about those. But when it comes to states like Missouri, where medical marijuana is now allowed, the analysis is a little bit more, there's a couple more steps, so to speak. How does medical marijuana compare to other prescription drugs? How controlled is it as a controlled substance? One of the issues that you run into, and it's not dissimilar from the opioid epidemic, is kind of casual use under the rubric of medical marijuana. It may not be as controlled as what is intended. A big issue with medical marijuana, especially compared to other medications and alcohol, like I mentioned, is dosage and frequency is unsettled and subjective. There is little analysis out there about what it means to be quote unquote impaired by marijuana. What is too much to be able to safely perform your job, or safely drive, or those sort of things. That's not really settled when it comes to marijuana. Unfortunately, a lot of this momentum towards marijuana in the public eye and public opinion and legislation is kind of speeding ahead of the science in terms of what we actually are able to say about dosage and impact on individuals who take it. And for that reason, when we talk about controlled substance, dosage and frequency being unsettled, those are the sort of things that are giving a lot of medical professionals pause. Even though you can become a medical professional who dispenses marijuana, a lot of major hospitals and nurse clinics are not jumping on that bandwagon. They're kind of shying away from that because of malpractice concerns, because of the uncertainty here. And then likewise, the VA, the Veterans Administration, because marijuana is still illegal at the federal level, they are not certifying patients because of the federal position on marijuana. So what comes next? Basically, as we've talked about, the trend here. Oh, yeah. I guess, sorry, I screwed up my slides already. Are these changes hurting anyone? I guess that's one of the questions that folks have. Okay, we've talked about marijuana. What is the true impact? No one can really say in terms of dosage and impact. So they've been trying to do some studies. The studies right now are kind of unsettled. It doesn't suggest that it has a huge impact. There's some that have found a slight increase, but other studies have found that states that are legalizing this, both for recreational and medicinal, aren't really seeing a landslide in unsafe practices and increase in accidents, those sort of things. So what comes next? Well, as Mariah pointed out, the trend here is favoring marijuana access, and it's likely that marijuana is going to be legal in some form in all states soon. Now, soon is very subjective because the legislation is moving quickly in some states, slowly in others. It's moving slowly at the federal level. The sort of headwinds at the federal level tend to change depending on which party tends to hold power at a particular time. So it's sort of hard to predict, but ultimately the trend is favoring marijuana access. As Mariah noted, descheduling of marijuana at the federal level is coming. And again, I can't tell you when, but it's something that you as an employer want to be ready for, because it's probably coming in the near future. On the other hand, it's not really going to be that much of a game changer at the end of the day, except for federally regulated positions, because so many states are already trending there even when the federal government isn't there yet. Now let's talk about a little bit of unique issues with marijuana. As I said, the biggest issue with marijuana is there's no accepted test for current impairment, which makes it different than alcohol or other drugs. That's a big problem. Another issue is, as far as medical use, like I mentioned earlier, in essence, it's more protected than alcohol now, because you have a card that an employee can show an employer and say, oh, but I'm allowed to take marijuana, my doctor says so. You don't get that with alcohol. Regarding the testing, the unique thing about marijuana is you can't test for immediate impairment or level of impairment. And as I mentioned, the science is slowly catching up, but it's not there yet. They're now developing and selling a THC breathalyzer, and THC is the active ingredient in marijuana, so to speak. Supposedly, there are breathalyzers that will now tell you if someone currently has THC in their system, if they're immediately impaired. The problem is, first off, those are kind of beta tested equipment. Second, even though it tells you whether or not someone is impaired currently, it doesn't tell you the level of impairment. So it's not like a breathalyzer where you blow a 0.08 and everybody knows what that means. So you can test for immediate impairment, but what does it tell you about whether or not someone is, unable to safely perform their job, for example? So let's kind of start walking through some of the analysis for employers. Fundamentally, the starting point is it's still okay to test. And again, this is changing in some states. New York, for example, is kind of limiting pre-employment testing for marijuana. Other states are talking about that. But when it comes to Missouri and Kansas, and Missouri in particular, because Missouri has adopted at least some legislation, it's still okay in Kansas and Missouri to test in essentially the manner that you currently are at the employer's discretion. Now, what you do with the test results tends to often be the issue that you run into in Kansas and Missouri when it comes to marijuana. Some things to think about as an employer as we kind of dive into this. First off, does federal law actually require employer action? Because as I mentioned, federal law, and Mariah mentioned this as well, federal law still prohibits marijuana, still considers marijuana to be an illegal controlled substance. There are federal jobs like commercial truck drivers, DOT regulated positions, safety sensitive positions, where drug testing is required as part of the process. And in those situations, state law loses out to federal law. Federal law trumps those. So if federal law says that those individuals need to be tested, then they need to be tested under federal law. But something else to then, assuming that that's not the issue that you have as an employer, then you start walking through the analysis of, is the job actually safety sensitive? Because when you can articulate that the job is safety sensitive, that takes you a long way towards essentially your discretion in how you want to handle marijuana. The issue that you run into a lot of times is, when you can't really consider the position to be safety sensitive, that's when you can run into issues in terms of what do we do with someone who tests positive for marijuana, but it's not really a position that is truly quote unquote safety sensitive. How do we handle that? That's where we turn to, is there reliable evidence of current impairment? Because you as an employer are still allowed to say that you cannot be under the influence of marijuana at work. And that is even for someone who has a medical marijuana card. And we'll talk about that a little bit more. The issue, so in other words, you can say you can't be under the influence at work, but as we mentioned, there's no great way of testing, there's no magic drug test that is going to tell you if someone is currently impaired at work by marijuana. So you then have to go to a step beyond that, which is you look for other evidence of current impairment, things like, smell, appearance, work performance, appearing disoriented, those sort of things. We'll talk about some of those. And then last of all, does that current impairment impact the ability to do the job? Because ultimately, if it's not safety sensitive, that's where the analysis comes down. You as the employer still have the ability to do, to take action against the employee if it appears, if you've got, a basis to believe that the individual is impaired currently at work and it's impacting the ability to do the job, then you are clear, to do what you want essentially with that. And we'll talk more about kind of what that means, but a little more framework on it. Some overall questions that employers are asking themselves nowadays, is it necessary or worthwhile to even test for marijuana? I don't really view that as a Kansas and Missouri issue. I think the analysis still favors testing for it. But some employers, especially, national employers or employers out on the coast, are starting to drop marijuana from drug tests altogether, as Mariah pointed out. Amazon is doing that. I don't think that that's going to be the last one that you hear about. One other question to ask, if you're doing pre-employment testing for alcohol use, or are you doing pre-employment testing for alcohol use? Because if you're not doing it for alcohol, think about, whether or not it makes sense to be doing it for marijuana. And again, I think for most employers in Kansas and Missouri, I'm not recommending dropping marijuana testing. It's still functionally relevant to you all. You just have to understand that the analysis is no longer as simple as a failed drug test and the employee has to go. Above all, as you work through these issues, because this is so highly evolving, don't be afraid of asking for help. These are the sort of things where it's important to swim with a buddy. These are unique issues for most employers. The folks at Axcet, myself, we see these more frequently than you do, hopefully. I'll confess, they're still, unique to us. We're getting hit with new stuff all the time, but nonetheless, we see it more often than you do. So when you do run into these issues, reach out, ask for help, because that can help guide you in the right direction. For one, these are very highly fact specific and very state specific. So we need to know kind of what's going on to be able to help advise and walk through that. Okay, so let's talk about kind of the simplest path forward. First off, essentially, if you treat medical marijuana like alcohol and prescription drugs, it's relatively, it's a straightforward way to think about it. In other words, it's acceptable unless the individual is impaired at work. But again, as I noted, you can prohibit usage at work, just like you would for alcohol, or just like you would for a prescription drug that is going to render someone unable to do the job. Anything that is, going to impair someone to the level where they can't do the job, you can absolutely prohibit usage at work. Even with medical marijuana being allowed, it still allows you, it still says the employee can't be under the influence at work. So let's walk through that in a little bit more detail. Let's talk Missouri, federal, and then state. Mariah covered this too, and so I don't want to plow the same ground, so we'll move fairly quickly through this, but I do want to point out a few things. Missouri's new law, it specifically does not allow for public use of marijuana or driving under the influence of marijuana. It does say that, a patient can't be punished simply for possessing marijuana, but usage of marijuana is still very highly regulated in Missouri. Patients are limited in terms of what they can do. Essentially, Missouri is expecting them to use it reasonably at the appropriate times. They're not allowed to undertake any task under the influence of marijuana if it would contribute to negligence or professional malpractice. They're not allowed to operate or control any dangerous device or vehicle. So as you can see, it's not like it's a free pass to just do what they want, even in Missouri. And the law specifically says that, a patient, let's say that you're in a car accident, someone's in a car accident while under the influence of medical marijuana, they can't use that to get out of a lawsuit claiming negligence for the accident. They're still going to be on the hook for that, even if they are prescribed medical marijuana. So, like I say, Missouri allows it, but regulates it in a way that puts the burden on the patient to use it responsibly and to take responsibility if the patient does not use it responsibly. Let's look specifically at the language regarding employment, because there is a section that specifically discusses employment. They can't bring, a medical marijuana patient can't bring a claim against an employer, a former employer, et cetera, for prohibiting the employee from being under the influence of marijuana at work. So again, you as the employer have the right to say that you can't be under the influence of marijuana at work. And likewise, an employee can't use medical marijuana to avoid disciplining someone for working or attempting to work under the influence of marijuana. So again, the burden is on the employee to use it responsibly and to use it outside of work. So the fact that the employee is using it at work, if you're able to prove that, if you've got a basis for that, Missouri law doesn't protect the employee from you taking action in that regard. Let's talk a little bit about marijuana at the federal level. As Mariah said, it's still illegal under the Federal Controlled Substances Act. It's been listed as a Schedule I substance for about 50 years. which means that it supposedly has no medicinal value and a high potential for abuse. As Mariah noted, Congress keeps talking about modifying this. Congress keeps proposing legislation. Nothing has passed yet, but it's just a matter of time. And what I mean by time, I don't know, but it's going to happen. It is just a matter of when. So that said, let me quickly reiterate, employees who are covered by things like, by a department like the DOT, you still need to follow DOT requirements because DOT requirements preempt state law. Let's shift to Kansas because, as Mariah noted, there's legislation pending in Kansas, and I won't replow that ground, but let me talk about what is allowed in Kansas and kind of touch on something that we'll discuss a little further as we go, which is CBD. Kansas does allow CBD, but Kansas is more restrictive than even most states and the federal government when it comes to CBD, because what Kansas says is that CBD is only allowed that when it contains no THC. And you can see the words on the slide. I'd try to pronounce them, but it's easier for me to just use the acronyms. But most CBD oil products contain at least 0.3% THC. And I'm no expert. I can't tell you if there is a way to make CBD that truly has 0 THC or not, but it is exceptionally difficult for someone in Kansas to even legally use CBD. So that doesn't stop people from getting CBD. It tends to be a little bit of a Wild West area right now in terms of whether it's actually enforced or not, in terms of whether the government is punishing folks or punishing, say, businesses that sell CBD that does have a little bit of THC in it. But just understand that if someone in Kansas is using CBD, odds are they're probably not using it technically legally, even in Kansas. One other thing, which is probably the more important point, because I do hear this, and I'm sure you all probably do as well. CBD, you have folks who Mariah, I'm getting chat messages that folks can't see the slides.
Yeah, I'm seeing that too. Let's see here.
While Mariah plays
slides yet.
How about that?
Sorry about that, guys.
Can we see the slides now? Is that if someone just gives a thumbs up in the chat or whatnot, I'll take that as a yes. Well, at any rate, let me move to my the point that I wanted to make on CBD, which is outside of Kansas. It is, you get employees who will test positive for marijuana and then say that they are using CBD. The issue that you run into then is it is extremely unlikely for someone to be taking legal CBD, which is the 0.3% THC. And when I say legal, I don't mean Kansas. I'm talking, federal and other states that allow a little bit of THC. The point is, if someone is failing a drug test for marijuana, which looks for THC, it means that they would have to be ingesting a substantial amount of CBD before they are supposed to be able to test positive on a marijuana test for THC. So I'm not saying don't believe it, but it is something that I want to point out so that you're at least aware of that fact, so that you don't give someone just an automatic free pass if they test positive for marijuana and they say, oh, but I'm just using CBD that I can go buy at the store, because that's extremely unlikely. I suppose it's theoretically possible, and so you want to look into it a little more, but don't just take that as absolutely true. Let me talk a little bit about how this relates to work comp and unemployment, medical marijuana. Several states, including Missouri and Kansas, they give discounts or credits for an employer's workers' compensation premiums or for unemployment benefits. Missouri, in particular, since they're the ones that have actually passed legislation on medical marijuana, use of a controlled substance in conformity with the lawful order of a healthcare practitioner is not unlawful. So when it comes to unemployment, medical marijuana, usage of medical marijuana is probably still going to allow someone to obtain unemployment benefits, at least when you're talking just straight usage. But again, as we talk about, it's a little bit risky if you are firing someone in Missouri simply for testing positive for marijuana when they have a medical marijuana card. When it comes to work comp, it's a little bit more complicated. Work comp actually reduces benefits 50% if the employee uses non-prescribed controlled drugs in the workplace or fails to obey a drug-free workplace policy. So then and in addition to that, if alcohol or non-prescribed controlled drugs are the proximate cause of the injury, then benefits are forfeited. And on top of that, refusal to test after an injury forfeits benefits if the employer had cause to suspect, or if the policy clearly allows post-injury testing. But the bottom line is be careful about relying on the policy as the only basis for alleging misconduct. Look for other additional signs of current impairment, which is a repeating refrain that you'll hear from me as we go. It's no longer usually just about a positive drug test. You also need to be looking for signs of current impairment. Let's talk a little bit about state line issues, given that we are here in Kansas City. Missouri employees working in Kansas essentially lose their medical marijuana protections when it comes to working in Kansas. They still have to follow the laws of Kansas if that's where the employer is based. So Missouri medical marijuana protections should not apply to a Kansas work site. What about a Kansas employee working in Missouri? A Kansas resident shouldn't be able to get a Missouri certification for medical marijuana. They can't use Missouri law to permit what's illegal in Kansas. And even Missouri, though, allows an employer to prohibit marijuana at work. So at the end of the day, both states, regardless of which side you're on, prohibit marijuana use at work. The only functional difference is that Missouri allows medical marijuana, so then you can get into accommodation type issues, but that would only be for a Missouri employee working for a Missouri employer with a Missouri medical marijuana card. And we'll talk through a little bit more as we go on that. How have the courts dealt with this? I want to talk about that briefly. Originally, this started out with a line of employer-friendly cases that were pretty positive for employers. And let me kind of move quickly through these because I want to sort of get to the main questions. But in essence, the early cases said because marijuana is still federally illegal, the ADA, the Americans with Disabilities Act, doesn't protect medical marijuana users. And that's where employees originally started trying to look at for legal protections because these state laws didn't exist. But now that we're getting more state laws in place, we're starting to see more employee-friendly cases. The good news is there's still a pretty clear line that the one thing that is prohibited is what I've talked about, repeatedly already. The one thing that's prohibited is just simply looking at a drug test and using that as the basis to make your decision. That tends to be what the employee-friendly cases have been situations where an individual, either an applicant or an employee, tests positive, and simply based on that test, the employee or the individual either isn't hired or the employee is terminated. And the reason why that's an issue is these states have statutes that specifically ban, doing that. So Missouri is not as clear on this point as a lot of these other states, but it would be a sort of risky proposition in Missouri to do that as well. So again, the point is, it's no longer just about a failed drug test. You need to look for other indication as well. Let me move briefly through a couple of situations just to show you kind of how this comes out. One is a case where an applicant was offered and accepted a job. It's sort of the typical thing. There was a drug test that had to be passed before the applicant could actually begin work. And she specifically told the potential employer that she took marijuana pills, which were legal to treat post-traumatic stress disorder. And she said that she took it only at night, not when at work. Now, nonetheless, the drug test came back positive, and so the nursing home rescinded the job offer. Well, the point is, she specifically was allowed to be taking it, and according to her, at least, she was only taking it at night. She wasn't taking it at work. And so near as the case shows, the employer had no reason to believe otherwise. The employer tried to argue federal law on this and point out that they have some federal contracts, and the Federal Drug-Free Workplace Act therefore means that federal law applies. And the court disagreed with that and said the Drug-Free Workplace Act doesn't really mean anything in terms of your obligations as a federal contractor. It's not like the DOT, which specifically requires things like drug testing. So in essence, the court simply said, look, you can't just vaguely point to federal law as a get out of jail free card when it comes to state law. Massachusetts and Rhode Island have reached similar conclusions. Both those cases were very similar, involved applicants who disclosed medical marijuana, specifically said they wouldn't consume marijuana while on the job, failed a drug test, and then weren't hired. And in essence, the same outcome. So again, you can't just rely on the failed drug test. You need to look for some reason that the individual is actually going to use or using marijuana at work. Arizona's dealt with this as well. This is a federal court applying Arizona law, but again, this is a situation where employee hurt herself at work, tested positive for marijuana. The employer fired her. But again, there wasn't any indication that the individual was actually currently using marijuana when she got hurt at work. So again, it was just the positive drug test that the employer was relying on. And the court said that's not enough. You need to give us some other indication that the individual was actually impaired at work. So let's talk about some workplace scenarios. How does this work in real life? You've essentially got two situations, pre-employment and post-hire. Another way to think of this is, situations that arise before there's an incident or someone tells you about marijuana, or when someone tells you about it, after an incident, when there's an incident and then you find out about marijuana use. We'll kind of walk through all of this. Pre-employment. Should you ask about marijuana or test for marijuana? This circles back to the points that we've talked about already. There's some places that are now saying that you can't. There's some employers who are saying that they won't. That's a decision that you as the employer, can make. But again, you're allowed to, at least in Missouri and Kansas, you are allowed to continue doing pre-employment drug testing. So then the question becomes, okay, you have an applicant that tests positive. What now? Well, let's talk about our three main players real fast. Federal law would say that the employer can do whatever they want with that failed drug test. Under federal law, that failed drug test is enough, to not make a job offer, to not hire the individual. The same goes with Kansas. It's up to the employer to decide what to do with that failed drug test. Missouri is more complicated because of the medical marijuana situation. That's where Missouri probably requires you to venture into the reasonable accommodation type discussion, with the emphasis being on whether or not the individual can do the job without currently using marijuana. And if so, then you find yourself in a bit of a gray area, when it's risky to not hire the individual simply because of the failed drug test. So in Missouri, you'll have to walk through things like, is the job safety sensitive? What is the individual's, how often does the individual use it? Those sort of things. And we'll walk through that in a couple of real life scenarios, or a couple more scenarios here as we go. So after hire, what happens if you as the employer learn of marijuana use after hire? Essentially, there's a couple ways that this comes up. Reasonable suspicion, or drug testing. That tends to be one way that it comes up. An individual fails a drug test, an employee fails a drug test, or there's some reasonable suspicion, odor, appearance, some sort of action by the individual that suggests marijuana use. That's one way to learn. Another is when the individual simply comes up and asks for an accommodation. In Missouri in particular, they both sort of revolve, to the second one, which is your best move is to think about it in terms of a request for accommodation. Let's talk a little bit about the Americans with Disabilities Act. As we've noted, federal law doesn't really chime in here in a way that limits employers. Drug testing is not a medical examination under the ADA, so you are still free to test. You'll see from this slide, and I need to move a little faster, so I'm going to sort of leave that for later. I know the slides will be sent to you, but in essence, current use of illegal drugs is not protected. But even for prescription drugs, you're not allowed as an employee to be under the influence or impaired at work in a way that interferes with job performance. So medical marijuana, federal law or state law isn't going to be, the situation where an accommodation requires you to allow poor performance or impaired abilities at work. Reasonable suspicion. What does it mean to have reasonable suspicion? These are things like physical characteristics, paraphernalia, behaviors. Things like possession, odor, appearance, behavior, speech. If you aren't familiar with marijuana and some of the things that would indicate marijuana usage, you can do some looking and kind of familiarize yourself. But in essence, there is, I'm not sure how you familiarize yourself on odor, but there's a fairly unique odor for marijuana, for example. And that would be an indication that someone is currently using marijuana, as opposed to simply failing a drug test, which doesn't show current impairment. So we run into some scenarios with repeat questions. Can we test the employee? What type of test is this considered? And what if a test shows positive for marijuana? What do we do next? So, Mariah, I actually want to, the next slide kind of lays out some scenarios. But let's skip past those and skip into the questions that you posed earlier, because I want to make sure that we go through those questions, get those questions answered, and then we'll circle back to these scenarios. So first off, these are walking through the questions that Mariah noted earlier. Do I need to stop conducting random drug testing? No, you don't. For the reasons that we've talked about before, Missouri, Kansas, and at the federal level, you're essentially allowed to test in the same fashion that you were before. It's simply a matter of what do you do when you get the test, a positive test result. Another common question, do I need to start drug testing now due to the change in laws? The answer to that, in my view, is no. If you haven't been drug testing before, there's nothing about the changes that suggests you need to start now. Now, that said, if you're in a safety sensitive industry or you have employees in safety sensitive positions, you probably already should have been drug testing. But the medical marijuana laws being passed don't require you to do more testing than you currently do. Let's talk quickly about a DOT regulated employer, because this one, again, is pretty straightforward. If you're regulated by federal policy, you must comply with those policies that still classify marijuana as an illegal drug. And the DOT has not done anything with regard to medical marijuana. They have talked about it. There's discussion that they will specifically address medical marijuana, but right now they haven't. So the current regular illegal drug rules still apply, even with all of the new medical marijuana laws. How does Missouri's law impact pre-employment and reasonable suspicion drug testing? Again, you can still conduct pre-employment and reasonable suspicion drug screening even in Missouri. And if you're an employer that doesn't have to worry about federal workplace implications, essentially, as I mentioned before, you can treat marijuana like you would prescription opioids. You are free to test. And the issue is, when you get a positive test, how do you handle it? And in that regard, you can handle it like you would for, a prescription for serious prescribed medications. If an employee or applicant says they're taking medical marijuana, one thing to do is essentially, first off, you don't have to take them at their word, and I would recommend that you don't take them at their word. One thing I tell employers all the time when it comes to disability accommodation type issues, medical type issues, you want the documentation from the doctor as opposed to what the individual says. So have the individual provide a doctor's note, have the individual show the card, something like that, so that you can document that the individual actually has permission to be taking medical marijuana. So last but not least, how does Missouri's law impact federal? It really doesn't. If you're bound by federal marijuana policy, a positive marijuana test remains a basis to deny unemployment, even if the individual has a medical marijuana card, or can produce a doctor's note. So, can I remove marijuana testing from my drug screen panel, and is that recommended? We've talked about this before. Some employers are doing this. Some states are saying that you can't do it at the pre-employment level. In Kansas and Missouri, it's still up to you. So, given that it's up to you, can you, should you? I do not recommend removing marijuana testing entirely. If you're in a safety sensitive industry, you still want to know if your employees are using marijuana, or say the individual is in a safety sensitive position. Even if it's legal medicinal, you still have a right to know. You still have a need to protect the public and other employees. So in essence, by removing it from the screening panel, you're essentially operating in the dark. And if something bad was to happen, a plaintiff suing you over a car accident that your employee gets into, for example, it doesn't necessarily look good for you to say that you no longer test for marijuana. Even if you don't have safety sensitive employees, that gets to this point. Accidents still happen, and you can still be vicariously liable for employees. So by continuing to leave it in your panel, you're at least showing an effort to avoid employees working under the influence. And again, as I mentioned earlier, the medical marijuana program in Missouri, it doesn't shield a medical marijuana user from liability for negligence connected to their marijuana use. Now, the problem for that is that means an employer can likewise be liable for the employee's negligence, which is the way that it's been for years in Missouri. So we don't recommend removing marijuana testing from your drug screen panel. You can, but we don't recommend it. Do I have to allow someone with a medical marijuana card to work in a safety sensitive role? No. This comes down to objective and observable standards. In essence, if you can articulate why someone with a medical marijuana card poses a danger in a particular position, then you do not have to allow the individual to work in that role. But again, the key there is to emphasize and articulate what it is about the position that makes it safety sensitive. And that's not a complicated burden. It just means taking the time to think it through. Maybe you beef up your job description a little bit with an explanation of why this is a safety sensitive position. Think about, whether someone can truly be harmed. But, this is sort of the difference between driving a forklift, for example, or working on, a production line, where you're just sort of passing boxes down the line. And I'm not saying that, passing boxes on a production line can't be safety sensitive either in the right circumstances, but it's pretty fact specific. But the good news is that puts it, gives you the ability to articulate what it is about that job at your employer, at your company, what it is that makes it safety sensitive. And if you can do that, then that gives you more control over whether someone, with medical marijuana is able to work that position or not, because if you can articulate why it's a safety sensitive position, that gives you a leg up in saying why someone, even with a medical marijuana card, can't work that position or shouldn't be working that position. How should I respond to an employee that voluntarily tells me they have a medical marijuana card? The first thing is remind the employee that they can't work under the influence. That is the absolute, bare minimum, every instance, make sure to remind the employee of that. If you have a drug-free workplace policy that would exclude medical marijuana from the premises, remind the employee of that. They are obligated to follow the drug-free workplace policy. If you have concerns that medical marijuana is going to impact the ability to meet production and safety standards, again, this is where I would say ask the employee to provide material from a doctor and then rely on that documentation. Look at that documentation and rely on it. It's not up to you to decide, or at least there's danger in you deciding. Likewise, you don't have to take the employee at their word that, they'll be fine. That's one where the best course of action is to require some documentation from a medical provider who actually is responsible for the medical marijuana. Another one is once you keep an eye out for signs of working under the influence. This isn't unique to an individual who voluntarily tells you they have a medical marijuana card. This is something to be doing for everyone, but that is an important step to keep in mind. Another one is, again, use objective, observable criteria for evaluating work, because that way you can document whether or not the individual, is meeting expectations. And if the individual isn't meeting expectations, then, it doesn't really matter if they're under the influence or not under the influence. You have the right to expect them to meet the job expectations. What if my employee fails a post-accident drug test but has a medical marijuana card? Is the position federally regulated? If so, then the medical marijuana prescription doesn't matter. Otherwise, think about whether the employee was under the influence at the time of the accident. It's not just about the drug test. It's about an indication that the employee was under the influence, smell, comments from the employee, those sort of things. And again, that can include asking the employee directly. Using the failed drug test for discipline or termination alone is risky. And again, if this is the first that you've heard the employee has a medical marijuana card, then go back to kind of what we discussed about before, when the employee finally comes forward and talks about having a medical marijuana card and kind of the steps to go through with that analysis. This one's an easy one, this next one. Does medical marijuana fall under the ADA, and what obligations or what accommodations am I obligated to provide? The ADA doesn't require, it doesn't fall under the ADA. So then it's a simple question of Missouri law. Missouri law is fuzzy on this right now. Missouri employment law has not discussed what to do with medical marijuana. There's been no cases or regulations that discuss it. As we've talked about, in essence, follow the same sort of accommodation discussion that you would follow for things like controlled substances, like prescribed opioids, those sort of things. So those are the obligations that you're required to provide is, basically someone can't be under the influence at work. And that's kind of the starting point. If you have the indication that they are, then you can act on that. Likewise, if all you have is information that they have a medical marijuana card, discipline based on that alone is risky. How does medical marijuana impact a workers' compensation claim? So as a general rule, this is going to depend on whether or not you can show that the individual was under the influence at work. And again, this is the problem that you run into, when it comes to, the good news is, marijuana use can still bar a work comp claim. The bad news is it's your burden as the employer to prove that the individual was intoxicated, was under the influence. So it's extremely important to look for other signs than the drug test to be able to help you meet your burden of showing that the individual was actually impaired at the time that the injury occurred. What does OSHA say about medical marijuana? Unfortunately, not much. Because it's a federal agency, marijuana is still illegal at the federal level, and OSHA really hasn't addressed medical marijuana. The only interaction really with OSHA at this point is you still as an employer have an overarching obligation to provide a safe workplace. So theoretically, someone, if you as an employer were to tolerate a bunch of drugs in your workplace, someone could theoretically say that you have an unsafe workplace because you're not controlling drugs. I'm going to assume that that's not an issue for most of you as employers. It is a reason why you do want to remain vigilant against drug use at your facilities. Another one that we've already talked about, so this one's fairly easy. Kansas employer with employees that live in Missouri, how does this apply to you? Kansas law controls, and so Kansas doesn't really change the equation. You proceed like you normally would, even if someone has a Missouri medical marijuana card. And what about CBD? Again, like we talked about, if someone comes to you with and claims to be using CBD and that was what caused the drug test, I would be skeptical of that, and I would, ask ask for, medical confirmation of that, something along those lines. Ask for a, doctor's information, because simply having CBD, simply taking CBD, even the CBD that has a little bit of THC in it, to be federally legal as THC or as CBD, it has so little THC in it that it should not appear on a drug test. It should not cause a positive drug test unless someone is using an exceptional amount of CBD. And at that point, if someone is using that much CBD is to be testing positive, then I suppose there's another question of whether the individual is impaired or able to do the job. So do some investigating in that regard, and the safest form of investigation in that regard is to ask for medical documentation, from a provider, a doctor's note. I'm running a little bit long, and so I don't. I'll tell you what. Let's skip past this one. The basic point on this one is there's low risk at this point of potential claims by employees, even in Missouri, based on medical marijuana. so long as you keep in mind that in Missouri, simply failing a drug test is not, you want to dig deeper before you take action against an employer and applicant. As we kind of wrap up here, what's your risk aversion? These are the sort of things to be thinking about, as you evaluate how you as an employer handle this. Are you more concerned about an accident on the job or being sued for discrimination? I would suggest to you as an employer that I would be more concerned about accidents on the job and less concerned about someone suing for discrimination because they have a medical marijuana card. Obviously, neither one is ideal, but accidents on the job, I think, are a much more serious concern. Being sued for discrimination for medical marijuana, it's a pretty gray area, employees, and should be a pretty limited cause of action in Missouri. So I would, between the two, I would favor safety on the job. Very briefly, some takeaways. Review your federal contracts, review your federal obligations, because your federal obligations can trump your state obligations. The other is, because you can no longer just rely on drug tests, or why it's risky to do that in Missouri, train your managers to identify impairment, have conversations about marijuana, so that your managers, who are the frontline people, they're the ones who can spot, things like someone appearing disoriented, someone, having the odor of marijuana, those sort of things that are the, sort of next level, the additional evidence of being under the influence at work that allows you as the employer to take action that you used to be able to take just for a failed drug test. So with that, that's the end of my presentation. It's a little after 10, and so I apologize for running a little bit long here. I'm happy to hang around for a little bit to answer any questions that folks have. As Mariah said, you can also drop them in the chat, and we can even communicate with you offline about them.
Yeah, I think we've got everybody's microphones here muted, but if you've got questions, if you can just drop them right in that chat there, either Brent or I will be happy to answer those questions for you guys. So don't hesitate. Go ahead and drop those in there for us if you have them. Not seeing any coming in just yet.
And I think, as Mariah said, you all will have the slides too. So definitely, if you think of issues when you look at the slides, and after you leave this conversation, something pops up in your head that you wish you would have asked, don't hesitate to reach out. We're happy to talk outside of this context.
Yeah. Awesome. Well, yep. And as Brent mentioned, I will be sending out a recording of our presentation today. And in addition to that, I'll send out a copy of the slide deck as well, so that you can have that on hand for your reference as well. But as we wait and just see if there's any questions that are coming in here, I want to say thank you so much to everybody for being on our webinar today. And thank you so much, Brent, for taking time out of your day to answer some really common questions and big things that we want to make sure that all of our clients with Axcet and anybody else who's joined us today are aware of. I just saw a question come in sharing slide decks. Yes, I will be sending those out either today or tomorrow. So keep an eye out in your inbox for those. The recording, making sure all the slides are presented on it. Yes, I will look into that. I'm sorry that happened. Not sure what happened there. Technology kind of gets us sometimes, but I will make sure that the recording goes out. And then if for some reason those slides aren't on the recording, you will have the slide deck as well to reference. So again, I apologize for that. Not sure what happened there. All right, well, we won't keep you here. I'm not seeing any other questions coming in, but again, please don't hesitate to reach out directly to me here at Axcet, or if you want to get in touch with Brent, I can definitely get you some information there too, so that we can get your questions answered. But thank you so much again, and I think we'll wrap up today. Thanks again, Brent.
Thank you.
Take care, everybody.